I'm extremely excited to be here this morning because a few months after I got appointed chair of the Council of Legal Education, we started the process of transforming the work that CLE does and how it does that work. And anybody who remembers that history will remember the very challenging period that I started with as chair. And I thank those who reached out to me. Professor P.L. Lumumba had conversations with me about how CLE can do its work better. At the heart of those conversations were several things, including how bar examinations is administered, including how we exercise our mandate of licensing and regulating legal education. But also critically was about what kind of legal education would we require into the future. And if you get the opportunity of looking at our strategic plan that we launched in April last year, I would invite you to look at the words that are then wrote as a forward to that strategic plan. Because in the third paragraph of my forward, I said, and I will quote, "Legal education for today's world must adapt to this new world and a new order of business. It must be bold enough to explore innovative tools and resources if it helps its graduates navigate legal issues with greater ease and confidence. Many countries across the world have begun to revisit their curricula on legal education and training. They have begun to rethink the knowledge and skills needed by the next generation of legal professionals. Those whose legal education focuses only on common law, for example, are slowly providing basic tools on civil law." I then said that the practice of law today requires agility, legal skills, ethics, professionalism, technological knowledge, and skill, all of which must be perceived as core outcome of any legal education and training, therefore signaling the need for us to rethink our legal education. And that rethinking, colleagues, is important because 66 years ago, in fact it was in December 1959 going to January 1960, in the UK, and thank you Deputy High Commissioner for being here, around 60 delegates from across the world, Chief Justices, met in London, chaired by the very famous Lord Denning, to look at the future of law in Africa. I think 6 decades later, there's increasing evidence that we need to relook at the future of legal education in Kenya and in the region. Relooking does not mean abandoning. Relooking means improving, means questioning, means interrogating. And therefore, one of the things that I committed myself to do as chair was to host a Future of Legal Education conference. And for the last 1.5 years, we have tried and made promises that we are hosting the Future of Legal Education, until at some point it became a song with colleagues at the council that, Chair, are you really sure that this conference will be held? So I'm extremely grateful to UNODC for partnering with us to be able to have this conversation, because it's a conversation that is long overdue. Over the last 2 weeks, by some strange fate, academics, practitioners have been having very interesting conversations on cyberspace about quality of legal education. There have been conversations, and I think the President of the Law Society has mentioned it, that are 902 being admitted one go, too much. And who do they blame? The Council of Legal Education. But 2 years ago, colleagues, we were being blamed for the exact opposite, that CLE is a gatekeeper. They refuse to admit people, that they fail people. When you do exams, we just fail you. Now, when 902 are being admitted, we are also blamed. You are damned if you do, and damned if you don't. Number 2, a few weeks ago, there have been heated conversations on cyberspace about how many law schools are enough for this country. How many should we license? On the other hand, CLE is told, you are not licensing people who apply. I can tell you applicants say, you are not licensing. In fact, Professor Dote, you are conflicted. As chair of CLE, who also sits at the University of Nairobi, you do not want any other person to be licensed. When people get licensed, we are told, you are licensing village universities. Colleagues, I invite you to look at the Legal Education Act and invite you to see what it asks us as our mandate. Our mandate is to consider every applicant and determine whether they meet the requirements of no. But I think the underlying conversation that we need to have, which is why this conference is there, is what kind of legal education providers do we require into the future? What kind of skills should they have? What kind of minimum requirements should they have? Because the state of legal education has changed tremendously from where it was when Professor P.L. Lumumba was teaching. We have an increased number of law schools offering LLB. As of today, we have 20 of them that have been licensed. And there are many other applicants. As of today, sitting before us, we have 7 applicants seeking also to provide legal education. So as you have the discourse, you must ask ourselves, from a regulatory point of view, what should the law provide more? What should the law provide differently? But we also have increased regulations, including from jurisprudence from the courts, on many things, on admissions of those that undertook their laws out of the country. We have conversations on whether in this age people should progress from diploma or not to do law, whether the minimum B requirements for English and Kiswahili is tenable in the current environment. We have conversations about decentralizing and devolving the provisions of advocates training program, court judgments. And those are things that we must be able to grapple with as a society, as a regulator. But we also have concerns about the quality of advocates entering the market. In fact, I've been telling colleagues who provide legal education that I think the challenge we have is not a competition between one law school or the other. The challenge we have is the overall assessment of our quality of advocates across the entire country. And that challenge is even more when you look at the increased number of non-lawyers who are self-representing in court and also representing others in court, and sometimes even doing a better job than ourselves. There are instances where, and the president of the Law Society is here, where there are people who have masqueraded as advocates, sometimes successfully for 2 years. So the question that it raises, what does that mean about our regulation? What does that mean about our training? When somebody who has not stepped into a law school, or as my former teacher and former Attorney General and Chair Emeritus of the Council of Legal Education used to warn us when he was teaching us that his duty was to ensure that when he looks at the class, he sees those of us who are much more suited to be butchermen, others who are much more suited to be farmers, others who are much more suited to be dancers. Nothing wrong with any of those things. But his duty was to ensure none of those people left the gates of university purporting to be lawyers. But now we have a situation where those butchermen, those dancers, those farmers, go to court, self-represent and represent others much better than ourselves at certain times until Faith and colleagues catch up with them for being masqueraders. Colleagues, if we look at the mirror, what does that mean about the quality of legal education? Question number 1. Question number 2, and Faith spoke to it. As we train lawyers, both at universities and at the Kenya School of Law, conveyancing is restricted still to conveying land in an environment where data, and I see my good friend Immaculate Kasait, the Commission of Data is here, is the new oil, where the subjects, the 9 P's that we teach, are principally focused on practice as being the practice that Gitobu Manyara knew, the practice where you practice at the Magistrates Court in Kibera, Nothing wrong with practicing at the Magistrates Court in Kibera. It now also has a high court by a very good friend of mine, where practice is at Milimani Commercial Court and Milimani High Court, and where practice is at the High Court at the Court of Appeal. In the 21st century, where majority of the lawyers practice everywhere else except those spaces, are we training for the market in the 21st century, or are we training for the market as it was then? Challenges for us to be able to address. Colleagues here have spoken about the regional perspective, globalization, commercial financial systems, and digital technologies increase the risk of money laundering, terrorism financing, corruption, and organized crime, all which demand new competencies from lawyers, prosecutors, judges, and regulators. As we have increased regional integration, as we have increased African continental integration, as we have increased discussions at the global space, despite the challenges that globalization is facing, the new lawyer is a lawyer that must be able to deal with questions about regional standards, mutual recognition of qualifications, and mobility of legal professionals. I'm glad the president of the Law Society spoke about it, because colleagues, we definitely have challenges around that space. But those challenges all being kept thrown to the doorstep of the Council of Legal Education. Even though, when you look at the law, there is what CLE should do in terms of administering the bar exams. There is what LSK must do. There's what the judiciary must do. And in the spirit of collaboration, we must stop the habit of pointing fingers to the next person. We must collectively find solutions that are fit for purpose. So that if we say we are going to have a reciprocal arrangement, it must be a reciprocal arrangement that we all respect. If we think there's a challenge, it must be a challenge that we all address and not ask CLE, what are you doing about it? We have nothing to do with reciprocity. Somebody else does. Please do it. So colleagues, as I end, what do I hope out of the next conversations? I hope that we can have a conversation about what kind of curriculum do we require. Is it a curriculum that is conceptual? Is it a curriculum that is practical? Let's look at what is happening in South Africa, for example. What kind of training do we require? Number 2, should law continue being a first degree or not? Number 3, what kind of pedagogy should we have for instructions of law? And number 4, what kind of areas of training should we infuse in our legal practice? I keep telling people that many years ago, when we were in school, every lawyer had to learn communication skills for lawyers. And something that I never understood, Professor Patricia Kamerimbote, HIV, AIDS, and the law as a common course. I do not know why we thought lawyers must learn about HIV, AIDS. And now that cancer is even worse than HIV, AIDS, why are we not learning cancer and the law? But in this modern age, if you do not learn technology and the law, you are definitely of the old generation. So we need to ask ourselves how we integrate technology and innovation in our teaching and in our learning. We also must be able to get ideas from you about how we improve our regulation and quality assurance. What can we do more? Is it about limiting the numbers? Is it about having greater standards? Is it about increasing regulations? We also need to ask ourselves the relationship, and I'm glad, I think tomorrow we are having the Commission on University Education. What is the appropriate balance between professional bodies and the Commission of University Education? How do we ensure that there's greater collaboration between the two of them for the purpose of improving standards? As we have these conversations, colleagues, we must keep in mind that students and young lawyers should not just be the subjects of our reforms, but must be co-creators of the future of legal education. Keeping in mind that the young of today are the old of tomorrow. So I see the former president of UNSA, who must now know that she is slowly leaving youth. So when you are young, please do not speak as if young is a permanent state of life. It is not. There will always be young people coming. So we must develop rules that are not just favorable for ourselves. We must develop rules that are trans-generational, that serve society in the long run. I'll be an extremely happy person when on Thursday, when we close this conference, we have been able to reimagine a future of legal education that is completely different from the one we have now. The one thing that will not make me happy is if we spend time lamenting, because the book of Lamentations is part of the Old Testament. The future can only be part of the New Testament. So please let us lament a little, but let us imagine more, because we expect as council that before we finish 2027, we must have contributed a lot to our vision of innovative legal professionals transforming society, and also to the mission of improving the quality of legal education. And the ideas you give us today will be extremely critical in that process. I want to thank you and wish us all very well in our deliberation of the next 3 days.